Good afternoon, everyone. Welcome to the seminar series organized by the Environmental, Energy and Climate Law Cluster under the CUHK Law's Center for Comparative and Transnational Law. For those of you who haven't had the pleasure to meet with, my name is Yue Zhao. I'm assistant professor here at the CUHK Law. It is truly our great pleasure today to have Professor Yue Zhao with us virtually, and Professor Zhao is going to present her research, which is titled Climate Change Litigation and its Potential Pathways in China. As some of you may know, climate change litigation has gained momentum as a climate policy tool. In recent years, increasing numbers of climate lawsuits have been brought by individuals and organizations across the globe. In the United States, for example, courts at various levels have heard over 1,000 public and private climate litigation cases. In Europe and Asia, citizens and NGOs have begun taking their governments and large emitters to court. These cases have really spurred important academic and public debates about the role of courts in responding to climate change and about the role that litigation can play to hold emitters and governments accountable. However, in China, climate change litigation remains a very new concept, and Professor Zhao's presentation today will aim to answer the below questions. What is climate change litigation? Is there climate change litigation in China? What will be the most promising pathway for climate change litigation in China? And how courts in China, an authoritarian country with a civil law tradition, react to government climate policies, and how this judicial response might affect relevant legal rules and eventually contribute to climate regulation. Before I give the floor to Professor Zhao, please allow me to briefly introduce our speaker. Professor Zhao is an associate research professor at the Faculty of Law, Sichuan University. She obtained the bachelor degree, Law and French, from Sichuan University, the master degree from the Faculty of Law, Peking University, and her PhD from the Faculty of Law, Université de Montréal. Her teaching and research areas include environmental law, international environmental law, climate change, and public international law. Professor Zhao has also published numerous articles on these topics. Professor Zhao will speak about 30 to 40 minutes, and after that, there will be a Q&A session. If you have any questions, please send those questions to me in the chat. I will collect your questions and ask Professor Zhao afterwards. Professor Zhao, the floor is yours. You have to unmute yourself. I think you're still muted.
Okay, thank you. Yeah. Can you hear me?
Yes, I can, perfectly.
Yeah, I'm going to share my screen. Okay. I believe you can all see my screen now.
Yes, we can.
Okay, then thank you. Thanks very much to Professor Zhang Hao. Thanks to your invitation to this seminar. I'm very honored. And I'm also very much delighted to be able to share my research, which has been accomplished 2 years before. And this research has already been published last year with Transnational Environmental Law. So during the process of my presentation, please do not hesitate to raise any questions. And if you have further questions, you can also go to read my paper for more details. So today we are going to talk about a very intriguing topic about the climate change litigation and its potential pathway in China. So first, what is climate change litigation? Have you ever heard about? I must recognize it. When I was drafting this paper, I've never heard about climate change litigation. My interest was initiated by this research, by this paper. Then climate change litigation, first, I would like to introduce a bit for you to have a better understanding of what it is and what is the regulatory pathway of climate change litigation. In brief, climate change litigation, and now it has already become a global judicial phenomenon. According to the Sabin Central Climate Change Litigation Database, there has already been 1,619 cases filed in at least 28 countries. Most of these cases happened in US, but we see a growing number of cases filed in developing countries, and the number is still growing. The total number is still growing. Although because of the pandemic of this year, the speed of the growth had slowed down a little bit, but it's still growing. I'm going to talk about some landmark cases for you to have a better understanding about what the global understanding or a general understanding, general account of climate change litigation is in the Western countries. First, I'm going to talk about a path-breaking case, Massachusetts versus US EPA, which was ruled in 2007. In this case, we call it landmark case and path-breaking case because it is the first case that's heard by US Supreme Court with regard to climate change issue, and it has shaped the federal regulation of climate change issues. In this case, US EPA, Environmental Protection Agency, refused to regulate carbon dioxide emitted by vehicles because it believed that according to Clean Air Act, the carbon dioxide is not a kind of air pollutant. So Massachusetts, along with 11 other states, bring the case to the Supreme Court. The judges are having an analysis the concept of air pollutant in Clean Air Act, ruled in favor of Massachusetts because according to the judge, the concept, the definition of air pollutant is capacious enough to encompass climate pollution, climate pollutant. So it decides it's under the purview of Environmental Protection Agency to regulate the greenhouse gases, unless it could determine that greenhouse gases do not contribute to climate change. Of course, it's not possible. Even the scientists could not do so. So that's the first case. It's a great success. And afterward, there's another case brought by US states. But this time they target not the federal government, they targeted the carbon majors, which means the emitters, the companies. They have targeted 5 entities, American Electric Power and others. So they believe that they are the main sources of climate pollutants in the US, so they should be responsible for what's happening now. And they search for to cap and to abate the emission of these companies. But in this case, this time Supreme Court refrained from adjudicating directly the tort-based climate change litigation, based on the belief that because Congress has trusted EPA in the first instance to decide how greenhouse gases should be regulated as defined by the Clean Air Act. And so it's not for the federal courts to issue their own regulations, to issue their own rules, because it would violate the principle, the separation of powers. It's the Congress and the administration's competence to do so. So the court at this time should not address such matters. So it's based on the political question or the displacement doctrine, etc., etc. But it set a very bad example for the tort-based litigation in US. Because afterward, all the tort-based litigation in US had proved to be a failure. And then there's another tort-based case, Luciano Liuya versus German company. This case is very special because it's filed in German court by a Peruvian farmer who lives in Peru and against Germany's largest electricity producer. It's very remote, the distance and the connection, but and what the farmer claimed that is, okay, he suffered from the climate-related landslide and flooding. So, and he believed that this German company should be responsible for that. Of course, this case was first dismissed by the German court because first, it's impossible to establish the causal relationship between particular greenhouse gas emissions, which suffered by this Peruvian farmer, and a particular climate change. The emission which was done by the Germany's largest electricity producer, and a particular climate change impacts which suffered by the Peruvian farmer. And even if the court finds we could establish the causal relationship, the decision could not make effective redress to help the government, help the farmer to address what he's facing now. It could not change nothing. Even if the court asked the emitter to stop emitting, the farmer in Peru will still be suffering. So, but in the appeal court, this decision has been changed. The court decided that it's admissible, but it's still for the Peruvian farmer to establish the causal relationship. And third, there are a series of other cases which is based on the rights and the constitutional rights of people and the regulatory, the statutory-based governmental responsibilities. All these cases, one is filed in Netherlands and another one is filed in Pakistan, are successful. So to conclude, there are basically two categories of cases. One, and each follows a different regulatory pathway. One is CCL focus on the government's regulatory behaviors. They have a purpose to challenge unlawful actions and inactions of the regulatory body, holding governments to their legislative and policy commitments. And the other one is CCL, targeting the carbon measures. They are tort-based. The main purpose of the plaintiffs is claim for injunctive relief based on tort law or to redress the climate-related injuries suffered by plaintiffs. But we can see for the first category of cases, the targeting the government, most of them could succeed. A lot of them could succeed. But for the tort-based cases, there are a lot of barriers, legal barriers in front of the judges put. So, but either way, we can see that in the Western countries, the climate change litigation does prove that courts could serve as alternative suppliers of climate change regulation, and CCL serve as a tool to influence policy outcomes and corporate behaviors. Sometimes the climate change litigation would push the government to adopt more ambitious goals to address climate change, and sometimes it could help them to adjust what they have done and to take more concrete measures in order to better respond to climate change. And sometimes the climate change would even directly influence or regulate the corporate behaviors, just as we have seen in the tort-based cases, though few of them have succeeded. So now we have an understanding of what's the global account or general account of CCL in the Western countries. I would like to put the CCL in the context of China to discover what is CCL in China. We are going to answer 3 questions. First, is there any climate change litigation in China? Second, how does Chinese climate change litigation differ from the standard account of CCL, which we have just introduced? Third, what would be the most likely channel for future possible climate change litigation in China? Okay, now we are going to first try to answer the first question, the fact question. Is there any climate change litigation in China? As I have just said, when I was doing this research, I have no idea of what climate change litigation is. I've never heard about it. And my friends asked me, one from France and one from Singapore, have you heard about it? Can you do a research on it? So I searched online. I find that even in the Sabin Center Climate Change Litigation database, there's no records from China. Then I keep searching. To my surprise, I found 2 documents issued by the Supreme People's Court in 2016. Both mentioned a concept of litigation as response to climate change. And they have classified this kind of litigation as response to climate change to 4 categories: carbon emission cases, energy conservation cases, green finance cases, and biodiversity conservation cases. I went to the High Court. I went to find the judges of the environmental tribunals and to ask what are these really about. None of them have any idea about it. So what we can do, we did an empirical study based on the China Judgment Online. We have at least found 177 relevant cases. We tried to code these cases according to different courses of actions, different plaintiffs and defendants, and the different outcomes of decisions. And it turns out we have observed 4 important trends in Chinese litigation as response to climate change. The first trend, most of these cases actually are overwhelming majority of these cases are contract-based cases. They are contractual disputes. And most of them generally involved energy management service contracts. So the second trend, unsurprisingly, is mainly the enterprises related to low carbon economy as plaintiffs and defendants that this case involved. In one typical case, the plaintiff, an energy service company, claimed that the defendant didn't perform its contractual obligation to share benefits generated from the energy management project. Yet, the defendant, who is a coke-powered plant, argued that as circumstances had changed, there was at a time a huge cost increase in the market. So he claimed that the contract should be modified accordingly, and the fulfillment of its obligation under the current contract would be unfair to the defendant. So that's generally what happened in this energy management service case or disputes. And usually, courts would adjudicate in favor of the plaintiff, which is the energy service company. And it led to our discovery of the third trend. We have discovered an obvious judicial tendency in favor of low carbon policy. So we tried to code the outcome of the cases to three categories: win, neutral, and lose. This does not tend to describe the subjective attitude or tendency of the judges, but we try to describe the effect of the case outcomes itself towards the climate change related issues. For example, if the case outcome could help strengthen the performance of the low carbon economy industries, then it will be marked win case, and vice versa. If it does not, it will be marked lose cases. But if we cannot clearly see the difference, we cannot clearly identify the effect, then it will be marked a neutral case. So according to what we have found, the win rate of cases is very much impressive, especially concerning when it concerns the carbon emission, energy conservation, and green finance cases. So sometimes they can even pass the 50% of the total number. When compared to the lose rate, which is just 70%, it's really very much important. It demonstrates that the Chinese courts is really doing something. It's really trying hard to help implementing Chinese government's low carbon economy, no carbon policy. It could give us this clue. And the fourth trend that we have discovered is that in these decisions, the judges would sometimes make even direct reference to governmental policies. It's quite rare because, you know, in China, Chinese judges are supposed to apply the laws by the legislators, made by the legislators, not the policies made by governments, if they are not considered law. But in their reasoning, they would refer to governmental policies to support their decision. For example, in one case, the plaintiff claimed that the defendant, who is a real estate developer, was liable for a breach of contract as it installed external solar power, water heating system, and charged the extra fees for that course, which was not within the scope of the original sales contract. The court dismissed the plaintiff's claim because he believed that the installation effected by the defendant is in line with the energy saving and low carbon policy requirements of the government, which should thus be supported and encouraged. Therefore, the plaintiff's claim was clearly inconsistent with the state's policy. So that's one case. In another case, similarly, it concerns a right of policy of the high polluting vehicles in this city. The judge even quote the rejuvenation of Chinese nation dream in its reasoning and adjudicate, of course, in favor of the people who representing the low carbon economy interest. So these are basically what we have found in our empirical study. Then how does this Chinese climate change litigation differ from the standard account of climate change litigation? I think the standard climate change litigation are mostly, especially the successful ones, are mostly administrative actions against the government, holding the government to their commitments to better address climate change challenges. And there are many statutory-based or rights-based litigations. And in these cases, judges play a central role in it. Judges are value-driven lawmakers. So courts, as we just said, serve as an alternative suppliers other than the government of the climate change regulation. But differently, in this litigation as response to climate change, in China, there are contracts-based litigation. It involves civil disputes between companies. Most of them are carbon emitters, but it's not the company's motivation to promote any climate change policy. They are just concerned about their contractual interests, their the fulfillment of the contractual obligations, the protection of their rights according to the contract. It is the court who is seeking to help implement public policies of the government on the low carbon economy. And these cases are very much policy oriented instead of law or judge oriented. So that's the basic and the most important difference that I found between these two kind of cases. So we can then conclude by saying that China has adopted a very different pathway of climate change litigation, which is a government-led pathway, in response to climate change, and leaving the courts with a secondary supporting role in these cases. But how did that happen? I think to explain this phenomenon, we should have a better understanding of the power arrangement in China. Different from most democratic common law countries, in China, courts is relatively weak compared to the Congress and the government, the administration. And so they have a very much limited judicial competence when they are trying to make a difference. We are trying to making a difference. And on the other hand, Chinese government did do a great job in addressing climate change challenges, especially compared with its counterparts in the US. So what the government is intending to do, the courts just follow. They just would like to help, would like to be a good helper, or some way like that, or some way like that. But does the climate change litigation in China like this count as the climate change litigation in its most general account? I think Professor Peel, Jacqueline Peel, has once proposed this concentric circle. There are some core cases in this concentric circle. They are litigation with climate change as central issue. They are important ones. They are what we have introduced at the very beginning of our presentation. But apart from these cases, there are still, at the outer limits of these cases, there are still litigation with no specific climate change framing, but implications for mitigation or adaptation. In that sense, I think the Chinese CCL, since it does have a good effect in helping strengthening the performance of low carbon economy, and so it is also climate change litigation in its broadest sense. And then we should raise the question whether the core climate change litigation could one day emerge in China, and through which way. I think now that we have understood that China has adopted a government-led pathway of climate change litigation, so this kind of pathway, to answer the former question, could be a double-edged sword for the climate change litigation involving public authority defendants. It might be a bad news because the judiciary part is very weak compared to the government, the Congress. So it would be unrealistic to count on the court to adjudicate against the government as long as the law has not prescribed the government's duty in addressing climate change. But on the other hand, it would be a good news for the tort-based climate change litigation. Yeah, since the dilemma that would face the US judges, especially considering the separation of powers, would not concern Chinese judges. Because once the government decided to do so, the courts would have a good motivation to creatively adjudicating cases. That's what we suppose. So is this true? Is this true? So I would like to propose a very good example to help us anticipate the most likely pathway for Chinese climate change litigation, which is the public interest litigation related to air pollution in China. This is a very good example because first, it has a very strong back of the governmental policy ever since 2013. The Chinese government is determined to make a change to curb the air pollution. So it has launched an anti-air pollution governmental policies, a series of them ever since 2013. And the new air law has been promulgated in 2015. And just the same year of the enactment of the law, the first tort-based public interest litigation on air pollution was filed in 2015. And ever since, there's a growing number of it filed in Chinese courts. And just after 1 year, you can see how fast it is. There was a first decision on the first case on air pollution. Usually the public interest litigation would last a really long time, but in the specific case of air pollution, the adjudication process has been really shortened to 1 year. That's very fast speed. Why I would bring up the public interest litigation on climate change, on air pollution, is because that I believe there is a lot of similarities between climate change and air pollution. They are both large-scale and cumulative changes in atmosphere caused by the use of traditional fossil energy. So they will face a lot of similar legal barriers when the case was brought to the courts. First, the justiciability problem, especially with regard to the standing problem. This standing problem is typically restrictive, especially in the US, as usually the plaintiff should prove that he suffered an injury, a concrete injury, which is reasonably traceable to the defendant. And this injury could be redressed by a favorable decision. In the field of climate change, we have seen that in a lot of cases, this is very, very much high standard of standing. And separation of powers, we've already talked about that. I think the most important similarity between the air pollution case and the climate change case is about the causation. The connection between a particular emission and any particular damage is usually too remote to constitute proximate causation. And remedies, as I have just mentioned, even if I ask one emitter to stop emitting, the pollution is still there. We can see no redressment. We can see no changes in the result. But how could we afterward redress or help to define the liability and the award of damages for harms suffered by the plaintiffs? So what I understand is that if the air pollution cases could overcome these legal barriers in Chinese courts, then the climate change cases could have a great potential to overcome similar legal barriers also in Chinese courts. So we are going to see what's happened. I say where there's a will, there's a way. Of course, here there's a will means the government's will, the policies. There's a way means that the courts does have creatively adopted law and even made new rules in order to make it work. Firstly, the standing issue. The standing issue is no longer a problem ever since 2015, because after the amendment to the new environmental protection law, environmental NGOs have now the standing before the courts to represent public interest with regard to environmental protection. And ever since 2017, the Chinese public prosecutors could bring both tort-based litigation and administrative litigation. So these two changes made it possible for Chinese NGOs and the Chinese prosecutors to bring similar cases. And there's another potential plaintiffs that's worth our attention, which is local government. There's a new regime we call ecological damage compensation litigation. And it's especially interesting in the field of climate change, because if you go and check what is the scope of the ecological damage compensation litigation, you will find the definition of the ecological damage is rather broad, and it's broad enough to include climate change even. So if I'm right that China has adopted the government-led pathway of climate change litigation, and now that local government have the standing before the court to file a case, and it could be climate change litigation from the definition part, then we can really waiting to see whether local government could bring such cases in future. And secondly, with regard to the causation question, we found that in the air pollution public interest litigation, as long as it concerns the non-compliance with environmental regulations, courts would easily recognize the establishment of a causal relationship between the emission and its adverse effect to the environment and to the public health. That's very unique, because that's not written in the law, and that's a rule that made by in the application of the law by the judges. I think that's also a proof that the government does play a very important part inside the whole process. I went to the High Court and asked the judges. They told me that sometimes the government would even provide sources of cases to the prosecutors. And they would tell the prosecutors that, okay, here there's a naughty boy who's keeping emitting and never stopped. So you might go and sue him. So that's what really happened behind the screen. And secondly, they have adopted the burden shifting rule and the relatedness instead of the causal relationship, which means the plaintiff do not have to establish the causal relationship, the causation between the injury and the emission. They just have to establish the relatedness between them. That's enough. And then it's the defendant to prove that this causal relationship does not exist. And we found that this rule does have been applied by Chinese judges in this public interest litigation. And third, with regard to injury and remedies, we can see that there are also some initiations made by Chinese judges. First, the direct impact of pollution on the ambient air per se is now accepted by the courts as a justiciable injury for remedy. And in the case of air pollution, it's very unique because once the air pollutants emitted in the air it would not stay there. It will go along by the wind. And when the case was filed, the most probable situation would be the pollution has already been cleaned up. So how can we say there's an injury? But the court just creatively said there's just an injury. If we think there's the whole atmosphere is polluted, then we can say that you have polluted the air, no matter whether it still exists there or not. Second, the injury in fact is replaced by the foreseeable harm. That's also a big advancement. Third, the environmental administrative authorities, they can intervene and provide supporting evidence to the plaintiffs, especially when the plaintiffs is environmental NGOs. That's also a very favorable rules for the plaintiffs to bring a similar case. So we can see that public interest litigation on air pollution could either be a convenient avenue for the climate change, considering the linkage between climate change and air pollution. Once we have abate the emission of air pollutant, we can anticipate that similarly the climate change pollutant could be reduced on the same time because they share the same sources. Usually they target the same companies. If we want them to make some changes, they would just adopt more energy saving, more energy friendly way of production. That's possible for them to do the same thing at the same time. And so even if Chinese public climate change litigation could not emerge, the environmental NGOs as well as local governments, prosecutors could still think about bringing public interest litigation on air pollution in order to address the same question. And second, public interest litigation on air pollution could also be not just a convenient way. Considering that it has provided so many favorable rules, so many favorable conditions for the plaintiffs to bring similar cases. In future, if the litigant would like to bring a climate change litigation in Chinese courts, they would also claim to use the same rules. So I think that's basically what we have done in our study. Thank you. And now I'm open to any comments and any questions. Thank you very much. Yeah.
Well, thank you. Thank you very much for the very thought-provoking and also informative presentation. I really have got a lot of questions in the chat. So let me start by asking you, because you mentioned this briefly about the comparison of climate litigation in the Western countries and also climate change litigations in China based on your empirical study. So the general framing question I would like to propose to you is, how do you expect global climate change litigation to affect China in the future?
Okay, to answer this question, I think as I just mentioned, Chinese climate change litigation is very much government-led, and so it's very government policy focused, and it's quite different from what's happening in the Western countries. I'm not very much optimistic about the influence and potential influence of them on Chinese climate change litigation. But if it could have an influence, probably it would be an influence on the NGOs. They would be more motivated to bring cases. But I'm not very much optimistic with cases brought by NGOs because they are really very weak compared to the government. And if they bring cases, usually they would target the government even. And the Chinese government and the Chinese court, whether they will let them succeed, I'm not quite sure. So I think that's also happening in the very typical case of the Friends of Nature. And you can see in the air pollutant case, air pollution public interest litigation, courts have just used 1 year to adjudicate, and that's really very fast, very, very fast. It's like the award has already been written, but in the case of the Friends of Nature versus national power grid, this case it takes already 3 years, I think, till now, already 3 years, and there's still no decision have been made. So what I would like to say is that Chinese climate change litigation, the pattern is really different from the Western ones. And we may not see a very close connection between them or any effect or any influence. There's another aspect that I would like to bring up is I think I just mentioned the local government as a potential plaintiffs of this climate change litigation. I think once the local governments are determined to bring climate change litigation in the courts, they would go and investigate what's happening in the world, what could be the potential pathways, and what's the claims that we would possibly make. And I think that might be another channel for the influence that you make. Okay, thank you for your question.
Thank you, Yue. I mean, since you mentioned that the climate change litigation in China is pretty much government-led, I think an outstanding issue here is about the different treatment between state-owned enterprises and also private-owned enterprises. Some scholars argue that state-owned enterprises do have some privileges in terms of, for example, not complying with environmental regulation. They can get away very easily. So based on your empirical study, by looking at the different types of plaintiff and defendants involving state-owned enterprises and private-owned enterprises, have you seen any difference in terms of the court litigation?
Okay. In my empirical study, the enterprises are many private enterprises that's targeted because they are energy serving management companies and companies with the energy saving demands, the contract between them. Sometimes the companies with energy saving demands would be the state-owned countries. But as they are against the policy, so the court would adjudicate against them. There's no difference according to my empirical study. But if they are sued, if they are real defendant in the real public interest litigation or in the real public climate change litigation, I think that there would be a difference. There would be a difference. The state-owned company have enjoy a very special status in China, as we all know. It's not just a company. Actually, it represents the interest of the state. And to represent the interest of state, they would say it represents the interest of the whole country. It represents the interest of the whole economy itself. And so they are closely related to the interest of the people. So how could public interest litigation filed against the interest of the people. So that there might be a contrast between them, a big contrast. So so that's briefly what I mean.
Well, thank you for sharing. And also, I mean, since you mentioned about the weak position of NGOs in China, and also the really powerful status of SOEs, I think the case you just briefly mentioned, Friends of Nature versus the power grid company in Gansu and Ningxia, I think is a very good example. So we'll come back to that case a bit later. I think it is very interesting that you mentioned the Chinese courts and Chinese judgments refer to the government policies on low carbon development and also decarbonization. So I think I've got two really interesting questions here. So let me start the first one by asking you that from your point of view, do you think those policies that the court judgments refer to are legally binding or not?
Okay. I think I must articulate more, because these policies, when the judges are quoting, they are not quoting it as what to say, as support. How to say?
As a basis.
As a basis of judgment, of decision. They just quote it to support their reasoning. So generally, these policies that they quoted are not legally binding. They are just governmental documents and promoting documented policies. Some of them are legally binding, and in our empirical study, we would count it as law, and we would not refer to it as policy. So, yeah, they would quote the legally binding policy documents, but they are no longer policy. They are actually the law in the broad sense. And this kind of document, this kind of law, they can be the basis of their judgment. Hello, Zhang Hao, can you hear me? Okay, where is Professor Zhang Hao? Okay, now I think since Professor Zhang Hao is offline. Okay, you're back.
Oh, sorry, I just had a computer crash for no reason. Sorry for the trouble.
That's okay.
So let me just follow up. Again, thank you for sharing your thoughts on that. A following up question on the court's reference to government policy is about, from your observation, do you think the Chinese court have been given the task to ensure consistency of implementing government low carbon policy?
I have friends working for the courts, the high courts. They have a lot of meetings to attend. A lot of policy meetings, a lot of all kinds of meetings that you can imagine. So as I have said, Chinese judges, if you want to better understand the system, Chinese judges are not interpreting bureaucrats. That's
so my interpretation of what you shared with us just now is that I think there's a sort of like internal coordination on informing judges about some of the very important policies in that area relevant to low carbon. That's a very interesting observation. And also another question here about Chinese court referring to the policies. And I think I have lost all the questions in the chat, unfortunately. And I think the question is actually from Grace. Grace, are you there? Let me just try if I can grab Grace. I think Grace is. Okay, here we go. I think I got it. So the question from Grace is, when court judgments expressly refers to the government policies, such as low carbon policy, does it mean that the Chinese judiciary is much more inclined to accept the state's defense of margin of appreciation, as often argued in the European Convention on Human Rights? I mean, it's a very complex issue. I guess the key issue, I mean, the purpose of the margin of appreciation obviously is to balance individual rights with national interest, as well as resolve any potential conflicts. I think the question, I mean, essentially is about the role of judiciary in China to resolve the conflict in state policy and also individual rights, as well as resolve any potential conflicts. So I was wondering if you can share any insights from your observation.
I think in these adjudications, the individual rights are not generally considered, but the public rights, the public rights with regard to the environmental protection. So that's quite different from the context that you mentioned in European Union. So there's no, they're not very good comparison between the two. So thank you. I don't know whether
finally the question about it does. I mean, you mentioned, I think you still, I mean, share a lot of really useful insights. The final question is about the Friends of Nature versus the State Power Grid Company in Gansu and Ningxia. I mean, for those of you who don't know much about the two cases, so Friends of Nature is NGO. So the NGO brought two cases in Gansu and Ningxia, so one case each in each of the province. So the case essentially is about the failure of those two grid companies to integrate renewable energy into the grid network, because under China's renewable energy law, there's an article stipulating that the grid company shall fully purchase all the renewable energy produced within the network boundary. So the question here, and also, I mean, the cases, as Professor Zhao just mentioned, both cases were actually dismissed at the very beginning. So one of the cases has been granted a retrial, but the retrial still ongoing. It's been years. So the question essentially is about what are the legal challenges in terms of the standing of NGOs when bringing cases to court. You mentioned that briefly in the tort-based climate change litigation, and I was just wondering if you can just elaborate a bit further on that.
I think the standing of the NGOs would not be is not the core issue of this case. The core issue of the case is the defendant, whether the defendant was appropriate. The court believed that the defendant is not appropriate because the state power grid itself was not a polluter. So the plaintiff, the court believed that the plaintiff failed to prove that the environmental damages could be attributed to the defendant's refusal to purchase clean energy. That does make sense to me, because really the grid company, they're not emitting themselves. It's the power factories they're emitting. So the connection is very remote. If the NGOs want to succeed, they must try even harder to establish the connection between it. And secondly, I think this case is facing a problem to prove that this lawsuit meets the conditions of the public interest litigation. So what is public interest? Whether because you are representing these companies, though they are low carbon companies, they are still private entities. The preconditions for civil public interest litigation must be primarily whether the public interest has been harmed or there were material risks. There must be polluting and disrupting behaviors if public interest litigation has to be applied. In both cases, I think the Friends of Nature have not done enough. They should try harder. I think that's what I understand about the case. The case is still pending, and it's now within the hand of mining area courts, and I believe that they are under great pressure to adjudicate. Yeah.
That's what I mean. Exactly as you mentioned, I think the case itself is not an easy process. Friends of Nature has been really facing enormous challenges of initiating the two cases and making sure that the case is going to move across the adjudication process. Because of the time limit, we really have to stop here. And I believe like the climate change litigation issue is going to be a very important area for research. And obviously, Professor Zhao is really like the pioneer in this area. It is, again, truly a great pleasure for us to have you here to share with us your research and also your thoughts. Just before you go, dear audiences, I would like to draw your attention to the upcoming events. You can really find those events on the CUHK Law website. For those of you who are interested, please do register, and also you'll be sent a Zoom link so that you can attend this seminar. So the first one is going to take place on the 16th of November, and I'm sure there are other upcoming events as well. The Symposium on Law and Politics of Unconstitutional Constitutional Amendments in Asia. So that's going to be a very interesting conference as well. And then another one is about constitutionalism and classical Confucianism, which is going to take place in early December. Again, please pay attention to the CUHK Law website for detailed information. Once again, thank you, Professor Zhao, for joining us, and I hope that we can communicate with you in the future. Please take care, and also the same wishes to everyone else as well. So enjoy the rest of your day. Bye for now.